Okay, so good evening once again. So medyo na-late ako kasi na-traffic. Ang gragang traffic pala dito sa Camarines Norte. Okay, so we end up kagabi sa right to speedy trial. So again, pag sinabi natin right to speedy trial, ibig sabihin, pag sinabi natin trial period, of course, hanggang 180 days lang yan. So meaning, kapag more than that days, yung 180 days trial period na natawag natin, ibig sabihin, wala tayong tinatawag na right to speedy trial or na-violate yung tinatawag na right to speedy trial. So meaning, it is our constitutional right, class, to have or to dispose or yung speedy or mas mabilis na pag-dispose ng mga kaso. So meaning dapat within that specific period of time, makapagbigay na ng decision or judgment yung particular case on any judicial, quasi-judicial, or administrative bodies. Kasi again, ang tinitingnan natin dyan or ang ini-aim natin, of course, na makuha yung tinatawag natin na justice. So ang right to speedy trial, it is our constitutional rights, di ba? Or it is our statutory rights as well na, of course, di ba, to have a speedy disposition of our case para malaman natin kung may kasalanan ba tayo or wala. So that's why very important yung tinatawag natin na right to speedy trial. Okay? Then, of course, we will have we have Republic Act number 8493, class. Yan yung ating special law when it comes sa Speedy Trial Act. Of course, tandaan ninyo, the arraignment period of an accused, pag sinabi natin arraignment, kung saan babasahan ng sakdal or babasahin yung information or complaint, that shall be held within 30 days from the filing of the information and of course from the date the accused appeared before the justice or kung saan judge ba yan or yung court in which the charge is pending or when the case is pending. So tandaan niyo ang Republic Act number 8490, that is the Speedy Trial Act na meron tayo. So meaning, piniprovide or pinoprovide niya dyan kung ilang days or particular days dapat masettle yung mga kaso, class, na merong hawak ang korte natin. Kaya it is our authority or is our right to demand yung tinatawag natin na right to speedy trial kasi that is granted by statute or by the special law. So yan, yung Republic Act number 84 and 93. Okay? So the right to speedy trial. Then, meron tayong tinatawag, class, na right to self-incrimination. When you are familiar with this, pag sinabi na natin right to self-incrimination, ibig sabihin, no person shall be compelled to be a witness against himself or herself. Ibig sabihin, hindi mo pwedeng kalabanin ang sarili mo, di ba? Of course, kailangan mo ipagtanggol ang sarili mo sa court of law. So that is a right against self-incrimination. So halimbawa, kapag pinera sa kanila na umamin na lamang sa kaso mo or sa ginagawa sa krimen, hindi, that is in violation of the right to self-incrimination. So meaning, no person should be compelled to be a witness against himself. And take note, class, kahit hindi ka abogado or lawyer ka man, you can have or you can, of course, pwede mong ipaglaban ang sarili mo sa loob ng korte. Okay? So, but of course, under the Constitution, no person shall be compelled to be a witness against himself or herself. Hindi mo pwedeng kalabanin or hindi pwedeng ipilit ng batas na, of course, magbigay siya ng mga statement or mga testimony na ipapahamak niya or na ikakapahamak niya. Or yun yung tinatawag natin na that is in violation against the self-incrimination na tinatawag natin. Okay? Then, of course, class, ang self-incrimination, there is an exemption to the rule, di ba? Ang self-incrimination, those are ang mga exemption dyan, yung mga mechanical process na ginagawa before ma-admit yung tao sa any court or any proceeding. So tandaan ninyo, halimbawa sa fingerprinting, okay, in fingerprintan ka, tandaan ninyo kapag sa fingerprinting, of course, hindi mo pwedeng sabihin na ayaw kang kuhaan ng fingerprint kasi that is against the self-incrimination. Hindi pwede yon. Hindi sakop ng tinatawag natin na right to self-incrimination ang pagkuha sa iyo ng fingerprint. Hindi mo pwedeng sabihin na may right ka against self-incrimination. Kasi nga, ang self-incrimination class that is only limited to the testimony or yung oral testimony mo class or wala kang dapat sabihin para hindi mo maipapahamak ang sarili mo. So hindi yan pasok sa fingerprinting. Then of course, we have the paraffin test. Okay, ang paraffin test to determine whether meron kang gun residue or gunpowder residue or yung particular person na yon is experiencing or nakapagpaputok ng barrel. So that is the purpose of paraffin test. Okay, relative to that class, okay, ano yung chemical or substance na ginagamit natin class in paraffin test to determine para magkaroon ng blue specks, ibig sabihin yung kapag it turn it blue, so meaning merong presence ng gunpowder or possible siya yung nagpaputok ng baril na yun. Ano yung ginagamit natin na chemical or substance na yung class? Sige nga, on the comment section, ano yung chemical or substance na ginagamit natin kapag nagpaputok yung tao na yun nagpaputok ng baril para ma-determine natin kung merong presence ng gunpowder residue. Sige nga, on the comment section, titignan natin. Sige, pag-type ninyo class sa Again, ang question natin, ano yung chemical na ginagamit natin class in paraffin test? Kung saan siya class, magiging blue siya, paraffin chemical. Nagsa-start siya class sa letter D. Nagsa-start sa letter D. Sige nga, hulaan ninyo. Ano yung chemical na ginagamit natin in paraffin test to determine whether that person is, ano lang ba niya, kakaputok ng baril or hindi? Sige, anong tawag natin na chemical doon, class? On the comment section, please. Anong chemical yon? Wala? Wala ba? Wala bang sagot? Nagsa-start sa letter D. Okay, anong chemical yun, class? Okay, very good, Leonard Valdez. That is diphenylamine. Okay, so very good. So this diphenylamine, that is the chemical class na ginagamit natin in paraffin test. Okay, so yan, diphenylamine. Very good, Leonard Valdez. So ayan, paraffin test, ang ginagamit natin chemical jet class is diphenylamine. Then of course, drug test, number 4 naman, X-ray. Pregnancy test for female, then we have police lineup. Ang police lineup class, of course, yung mga suspected individuals, naka-line up yan sila 7 to 10 individuals, tapos ituturo yan ng biktima kung sino yung gumawa ng krimen. Ang tawag natin dyan is police lineup. Number 7 naman, to submit to a test to extract virus from his body, compelling him to expectorate the morphine from his mouth. We have RA number 1379, forfeiture of illegally obtained wealth, or yun yung tinatawag natin na unexplained wealth. And of course, number 9, Republic Act 749, yung mga bribery and graft cases. Again, ang self-incrimination, ibig sabihin nun, you are not, or no person shall be compelled to testify against himself or against herself. So meaning, hindi mo pwedeng kalabanin or hindi mo pwedeng ipahamak ang sarili mo. So that is, of course, ang hindi makakasali ito yon, yung 1 to 10. So that is an exemption from self-incrimination. Yung mga mechanical process class, yung mga precaution before ka papasok doon sa, halimbawa, sa korte or sa kulungan. Then, of course, meron tayong tinatawag na rights to political beliefs and aspirations and involuntary servitude. So meaning, no person shall be detained solely by reason of the political beliefs and aspiration. Ibig sabihin, kailangan nating respetuhin kung ano yung kanyang political beliefs, okay? So meaning, hindi mo pwedeng i-imprison or hindi mo pwedeng ikulong yung tao na yon kasi iba yung paniniwala niya sa paniniwala mo. Okay, that is Section 18. No person shall be detained solely by reason of political beliefs and aspiration. The provision prohibits the punishment of anyone who wished to join any political party which we believe would help in the development of the country. Ibig sabihin, hayaan mo sila or hayaan mo ibang tao to join any political party which they believe na makadevelop or makapagbigay ng change sa ating country. Okay? So, yan yung tinatawag natin na the rights to political beliefs and aspirations and yung tinatawag natin na involuntary servitude. Okay? So, yan. Then, of course, we have Article 4, yung tinatawag natin na freedom from slavery. Okay, sa Article 4 class, we have the freedom from slavery. Ibig sabihin, no one has the right to treat you as a slave, nor should you enslave anyone. Again, so halimbawa, ang slavery class, ibig sabihin, pwedeng gikidnap ka, kinuha ka, for the purpose of enslaving you. Ibig sabihin, papatrabahuin ka, na walang bayad, gagawin kang sex slave, okay? Gagawin kang may papagawa sa iyo, of course, na walang kapalit. Or yung parang tataratuhin ka talagang hayop, di ba? Slavery ang tawag natin doon. So, ibig sabihin, under Article 4, no one has the right to treat you as slave, nor should you enslave anyone. Ibig sabihin, wala kang karapatan na tratuhin na slave yung iba. Then, of course, hindi rin pwedeng ikaw yung gumawa yan sa kapwa mo. Then, no one shall be held in slavery or servitude. Ibig sabihin, itago ka. Hindi ka ipakita sa pamilya mo. Wala kang liberty. And slavery and the slave trade shall be prohibited in their all forms. The said act also punishable under the revised penal code. Of course, yung slavery mamaya ma-explain natin on the next slide. Okay, so tanda niyo class, ang slavery under the RPC, ang penalty niyan is prison mayor. Then of course, ang fine is not exceeding 10,000 pesos. Kapag anyone who shall purchase, ibig sabihin binili mo, binenta mo yung tao na yan sa iba, kinidnap mo, or you detain human being for the purpose of enslaving them. Okay? Enslaving him or enslaving her, that is slavery. Ibig sabihin, ang purpose mo, binili mo, binenta mo sa iba, kinidnap mo or detain mo yung human being for the purpose of enslaving them, that is a crime of slavery under the revised penal code. Okay? Okay, then of course, that is sa Section 4, Article 2 class, the prime duty of the government is to serve and protect the people. So the government, then, okay, tanda na yun, the government may call upon the people to defend the state, okay, to defend the state in the fulfillment thereof. All citizens may be required under conditions provided by law to render personal, military, or civil service. That's why, class, pagdating ng war, whether you like it or not, kailangan mong ipagtanggol ang sarili mo or kailangan mong ipagtanggol ang bansa natin. Halimbawa, you are not a member of the armed forces or you're not a member of the Philippine National Police. But then again, kapag nagkakubusan na, kailangan mo i-defensahan or kailangan mo i-defend ang sarili mo, okay, not just yourself, of course, your country, kahit na konti na lang kayo. Kahit hindi ka marunong humawak ng baril, kailangan mo matutunan yan. Kasi nga, kailangan ka ng bansa or yung bansa natin is facing state of emergency. Okay, lalo na during war. Kailangan na kailangan ka, okay, whether personal, military, or civil service, you have to defend yourself upon the call of duty or upon the call of the government. Ibig sabihin, all citizens, no one is exempted. Of course, kailangan mong ipagtanggol ang ating bansa. Okay? So, diba, ang mamatay ng dahil sa'yo, so yun doon. Okay? So, ibig sabihin, meron kang sense of nationalism. Okay, of course, class, ang exemption in voluntary servitude for service in defense of the state and so on, huwag nyo na masyadong i-focus to class kasi ang kailangan na naman natin is basic na alam nyo what is what we call yung tinatawag natin na involuntary servitude, and of course, yung pag-serve sa country natin. Okay? Then, of course, dito tayo. Ang rights against excessive fines class, ibig sabihin, ang government natin or ang state shall not impose class. Hindi pwedeng mag-impose ng cruel, ibig sabihin yung hindi makatao, or yung tinatawag natin na degrading or inhumane punishment inflicted. Ibig sabihin, sobra-sobra yung binigay na punishment or penalty that is not allowed by law. Kasi meron di ba tayong tinatawag na just desert theory, the punishment should fit the crime. Okay, tandaan niyo? So, hindi yan pwede yung sobra-sobra. Then on the second paragraph, the employment of physical, psychological, or degrading punishment against any prisoner or detainee or the use of substandard or inadequate penal facilities under inhumane or subhuman condition shall be dealt with by law. But still, hindi na susunod yan, class. Kasi kung titingnan ninyo, still the number one common problem or the major problem na kinakaharap ng prison system na meron tayo sa Pilipinas ngayon is the overcrowding. Ibig sabihin, yung capacity sana, class, ng kulungan na yan is nasa 10,000. Ang nangyayari, nasa 50, o di ba? 50,000 and so on. So, ibig sabihin, substandard na. Hindi na susunod yung nakalagay sa Constitution. Okay? Kasi nga, di ba, of course, kailangan na nila, kahit nakakulong sila, kailangan na nila ng standard rin or the best rin. Okay? Kailangan natin silang i-threat na, of course, they are still, of course, they are still part of our community. So, kailangan natin sila, of course, protektahan or kailangan natin ibigay yung the best. Kaya, di ba, yung sa ibang bansa, kung titingnan niyo, ang kanilang mga kulungan ay very standard or kumbaga, ano talaga, ang ganda ng mga facilities and of course, given na konti lang yung gumagawa ng krimen, di ba? Okay, kapag tinanong sa board exam class, ano yung bansa na yung mga prison ang mga prison cells nila or yung mga kulungan nila walang laman. Zero sila, 0% or zero yung tinatawag nila na mga nakakulong doon. Okay? Anong bansa yun, class? Kung saan walang nakakulong or minsan meron pero ano rin yung minor crimes lang. Kaya yun yung tinatawag natin na prisons without, of course, without yung mga tinatawag natin na clients or yung mga PDL. Anong bansa yon? Okay? No. Nagsa-start po siya sa letter N. Letter N. Okay, it is in the part of Europe plus. Sa part siya ng Europe. Okay, very good, Sir Mondelo. Ang sagot natin dyan, that is the Netherlands. Okay? Netherlands po. The Netherlands. Okay? Sila yung mga kulungan na walang laman ang kanilang, walang laman na preso doon sa Netherlands. Okay? So yan yung the Netherlands. Okay? Yan. Next. Okay, dito tayo, class. Pakibasa nga nandito ba si Nasim? Nasim, okay. Nasim, ng ating illustration 1 under excessive fines. Then sasagutin natin.
Yes, po, sir. Yes. Excessive fines. Felipe was heavily drunk in the evening of May 20, 2020. Without any reason, he took his gun and fired it the air for several times. Due to such acts, he was apprehended by the police when the neighbor judge Magtas reported the incidents. A case of alarms and scandals under Article 155 of the revised penal code was filed against him. Fortunately, the case files in the hand of Judge Magtas. After the trial of the case, Felipe was convicted to the crime committed and sentenced to the penalty of arresto menor and the fine of 500,000 pesos. Felipe questions the decisions, particularly to the fine, of being excessive. Is Felipe is correct?
Okay, sige. Ilagay niyo mga question, ang sagot niyo, class, sa comment section. So basahin ko ulit ang tanong. So Felipe was heavily drunk in the evening of May 20, 2020. Without any reason, he took his gun and fired it in the air for several times. Due to such acts, he was apprehended by the police when his neighbor Judge Mangtas reported the incident. A case of alarms and scandal under Article 155 of the revised penal code was filed against him. Fortunately, the case falls in the hand of Judge Mangtas. After the trial of the case, Felipe was convicted to the crime committed and sentenced to the penalty of arresto minor and a fine of 500,000 pesos. Felipe questioned the decision, particularly the fine, for being excessive. Is Felipe correct? So, justifiable ba or tama ba yung binigay ni Judge Mangtas na 500,000 pesos for the crime of alarms and scandal? Okay, pakilagay nga doon sa comment section. Is it a yes or no? Sige nga. Lahat mag-participate class ha, yung 20 participants natin. Okay, yes or no. Kapag meron kayong justifiable or meron kayong justification, much better. Okay, para babasahin natin ang mga justification ninyo. Bakit correct? Bakit correct si Felipe? Bakit hindi? Sige nga. Saan yung iba? Lahat sumagot class. Malaki masyado ang 500,000 pesos. Yes, since under Article 155, the fine of arrest minor not exceed the amount of 40,000. Okay? Wow, very good. Kasi ang fine na dapat 40,000. Yes, very good kasi na-remember niyo kanina yung sinabi ko. Okay, so let's discuss this. Discuss na natin ang sagot class. Of course, ito yung ating sagot dyan. Okay? So, okay. Very good, Check Kanoy. Good. So, Felipe is correct. Of course, the penalty for imprisonment of arresto minor is proper. Tama yung arresto minor, But yung fine class is 500,000 pesos is sobra-sobra naman. That is excessive kasi under Article 155 of the RPC, ang alarms and scandal, of course, arresto minor, ang fine niya will not exceed 40,000 pesos. Tanda niyo? 40,000 pesos. So, sino ba yung nakakasuhan ng alarms and scandal? Ang alarms and scandal kapag any person within any town or public place shall discharge yung firearm niya sa air, rocket, firecracker, or other explosive that cause alarm or danger to the community or to the society, kakasuhan siya ngayon ng alarms and scandal. Okay? So on the basis of the amount mentioned nyo or about the mentioned law, it is clear that the judge, of course si Judge Mangtas, abused his discretion in meting out the excessive fines against Felipe, which tantamount to a violation of his right against excessive fines. The law is clear that the fine should not exceed 40,000 pesos. So meaning, na-violate ni Judge, aside from na-violate niya yung tinatawag natin yung grave abuse o yung discretion, ibig sabihin, he took advantage, of his authority, of his influence. So that's why, but then again, yung 40,000 pesos, ginawa niyang 500,000 pesos. So that's why it is against the constitutional right of of the of course the biktima, okay, yung ano natin, perpetrator, sorry, that is against the excessive fine. So that is Felipe is correct. Pero tama yung arresto minor class pero ang mali lang doon yung tinatawag natin na excessive fines na binigay ni Judge Mangtas. Does not equate sa tinatawag natin na severity ng crime na nakomit niya. Nakuha ba? Naintindihan ninyo? Naintindihan niyo ba? Okay, so in that way, class,
Yes, sir.
Okay, thank you. So natuturuan ko kayo on how to think critically. Ibig sabihin, kahit anong ibato sa inyo sa board exam class na mga tanong, masasagot at masasagot ninyo, di ba? Kasi natuturuan na kayo dito ng how to answer case analysis question. Okay? So let's move on now, class, on the next slide. Okay, so meron tayong tinatawag na degrading punishment. Of course, sino naman yung magbasa ng another illustration or another case analysis. Kasi i-prepare ko talaga to para ma-train kayo on how to think. Kasi lahat ng mga area pwede niyo magamit to. Si Tigulo, Carlo, available ba si Tigulo?
Sir, available po.
Sige, go ahead. Thank you.
Degrading punishment. A group of robbers and bank during the police investigation. One of the suspects was identified by the bank employee. A hot pursuit operation was conducted against the suspect, who was identified as the ghoul. The ghoul was successfully apprehended during the operation. Recovered from his possession or money amount to 50,000 and for caliber 45 pistol. In order to be able to identify his companions, the ghoul was subjected to torture by the investigating police. Is the act of the police violates the constitutional rights of the ghoul?
Okay, thank you. Okay, so I will read the question again, then pakilagay ng sagot ninyo sa baba. So under the degrading punishment tayo, class. So a group of robbed a bank during the police investigation. One of the suspects was identified by a bank employee. A hot pursuit operation was conducted against the suspect, who was identified as the ghoul. The ghoul was successfully apprehended during the operation. Recovered from his possession are money amounting to 50,000 pesos and a caliber 45 pistol. In order to be able to identify his companions, yung mga kasamahan niya, the ghoul was subjected to torture by investigating police. Is the act of police violates the constitutional rights of the ghoul? Yes or no? And why? On the comment section, class, lahat mag-participate para mas maganda yung ating interaction. Yes, the investigator may violate the RA 7438. Okay, so let's discuss, class. Okay, so let's discuss. So dito tayo. Of course, the investigating policeman violated the constitutional rights of the goal against degrading punishment. So hindi naman kailangan gumamit ng dahas, class, para mapaamin si Dagol kung sino pa yung mga kasamahan niya, di ba? So such act is obviously violates the constitutional rights of the goal. Moreover, the act of policeman is punishable under Republic Act 9745, yung tinatawag natin ngayon, the Anti-Torture Act of 2019. Again, hindi natin hindi natin kailangan yung tinatawag natin na degrading punishment or yung tinatawag natin na, of course, RA 74 ay RA 9745, yan yung tinatawag natin. Okay? So ayan, physical and of course inhumane punishment. Very good, si Che. Yes, yung sinagot ni si Che is under the what they call the Constitution. Si ano naman is the special law. So again, ang sagot natin dyan, of course, na-violate niya yung constitutional rights ni Dagol under yung tinatawag natin, of course, yung hindi kailangan mag-enforce ng force or inhumane or degrading punishment. Okay, or torture, bawal ang tinatawag natin na torture to extract confession. So bawal yan. Okay, so yan. I hope it's clear. Okay, dito tayo. Okay, the rights against imprisonment for non-payment of debt or poll tax. Tandaan nyo, class, walang nakukulong on the non-payment of debt or yung utang ninyo. That's why, di ba, ang kakapal ng mga mukha ng nangungutang ngayon. Kasi di ba alam nila na hindi sila makukulong. Okay? Nakuha ninyo? Of course, class, that is under our Constitution. Okay, and that is under our Constitution. But then again, meron tayong tinatawag na another way kung paano natin sila masampahan ng kaso. So pwede natin silang sampahan ng kaso na tinatawag natin na unjust vexation. Ibig sabihin, di ba, ang unjust vexation, it catch all crimes under the revised penal code. So pwede mo isampayan kahit kapag kulang yung mga elements. Since sabi ng Constitution or sabi ng batas natin, walang makukulong for non-payment of taxes or non-payment of debt rather or poll tax na tinatawag natin. So meaning, anong mangyayari dyan? Ano yung magiging remedy natin? Of course, may remedy tayo. Pwede natin silang sampahan ng kasong unjust vexation kasi it causes you discomfort, naiinis ka na. So pwede ka magsampa ng kasong unjust vexation. Then kasi, class, kahit may utang yung tao sa'yo, hindi mo rin pwedeng kunin yung mga bagay o yung mga properties. Or halimbawa, may utang siya na 20,000 sa'yo. Kapag pumunta ka sa bahay nila, kinuha mo yung mga gamit, yung refrigerator, kinuha mo yung TV nila, lahat dyan, yung oven, ikaw yung makakasuhan. Anong ang kiyakaso sa'yo, class? Kapag kinuha mo yung mga bagay belonging to your debtor or belonging sa nangutang sa'yo, okay? Nangutang siya sa'yo, pero hindi siya makabayad, kinuha mo lahat ng gamit niya na mapapakinabangan mo para as part of payment sa utang niya sa'yo. Okay. Ano ang tawag natin doon? Or ano yung particular crime na makukumit niya? Again, ano yung particular crime na makukumit natin kapag you seize anything or kinuha mo yung mga bagay belonging to your debtor as part of their payment of their debt? Okay, so ano yun? Okay, very good. So ang sagot natin dyan, that is light coercion. Okay? Light coercion, ibig sabihin, non-payment of what they call yung tinatawag natin na okay, yung hindi mo pwedeng kunin or you're not allowed to seize anything belonging to your debtor pag may-ari ng nangutang sa'yo as part of their penalty or as part of their payment sa utang nila. So that is bawal. Okay? That is not allowed under the Philippine law. So ang sagot natin dyan is light coercion. Okay, very good. Then the law prohibited anyone to put into prison a person who has indebted them, yung nangutang sa nila. The state is likewise prohibited from putting a person to imprisonment for non-payment of all taxes o yung tinatawag natin na cedula. Okay, di ba kailangan din natin magkuha ng cedula para ma-determine kung magkano yung kita natin for that whole duration of the year. Okay? So that's why walang makukulong or non-payment of poll or cedula. Okay? Then of course, meron tayong tinatawag na illustration number 3. Sino kaya? Si Che? Che Canoy? Available na ba si Che ang kanyang microphone?
Okay, so Miss po.
Sige. Thank you.
Okay. Miss Hua borrowed money from Miss Ba Wang in the amount of 500 pesos, as a 500,000 pesos, as a security to her debt. Miss Hua issued a check corresponding the amount she borrowed. Without the knowledge of Miss Ba Wang, the check issued to her, Miss Ba Wang, has no longer a fund because it is a closed account. When the check was negotiated to the bank on the date given, the bank refused to give the money for a reason that the said check is a closed account. Ms. Hua filed a case of estafa against Ms. Ba Wang for issuing a closed account check. Ms. Ba Wang moved to dismiss the case because it is a violation to her constitutional right against non-payment of a debt. Is Miss Ba Wang's right is violated by the filing of a case against her? Medyo nakakalito yung name, sir. Sorry.
Okay lang. Okay, so thank you. Ayan, so actually ano yan, miswa yung nilalagay sa ano yan, sa sardinas. Then bawang. Okay, so yan, bawang. Okay. Sige, okay lang. Thank you. Okay, ulitin ko yung tanong. Miswa borrowed money from Miss Bawang in the amount of, ang borrowed that is letter O, 500,000 pesos. As a security to her debt, Ms. Hua issued a check corresponding the amount she borrowed. Without the knowledge of Ms. Bawang, the check issued to her by Ms. Hua has no longer a fund because it is a closed account. When the check was negotiated to the bank, yung pinalitan niya na class para maging money, on the date given, the bank refused to give the money for a reason that the said check is a closed account. Ms. Hua filed a case of estafa against Ms. Bawang for issuing a closed account check. Ms. Bawang moved to dismiss the case because it is a violation to her constitutional right against non-payment of a debt. Is Ms. Bawang's right is violated by filing of a case against her? Yes or no? Sige nga, maki-justify nga sa comment section class kung tama ba yun, na-violate ba yung right ni Ms. Bawang, okay? O yung constitutional right niya against non-payment of debt. Sige nga. Kasi sinampahan siya, di ba, ng kasong estafa, di ba? Kasi nag-issued siya ng walang laman or closed accounts na check. Okay, so sige nga, on the comment section class, sige, babasahin natin. Bakit isa lang sumagot, class? Isa lang, sina Sim? No, yung nag-file ng cases hindi about sa non-payment of debt, yung cases about sa check. For me, no, sir, since there is a check issue. Sige nga. Okay, some other class, other insights para malaman natin, ma-compare natin kung tama yung mga sinasagot ninyo. Okay, saan yung iba class? Sasagutin natin 5 minutes, ay 3 minutes na, 3 minutes. No, hindi siya na-violate since she may be held liable. Saan yan? Meron ako nakita. No, hindi siya na-violate since she may be held liable for the case of BP22 that deals with a criminal offense of issuing bouncing check. Ay, ampot. Okay. Sige. Naguguluhan po ako, pero basta alam po no, sir. Sige. Okay. No sagot ko pero di ko alam i-explain. Don't worry, class. Ang tinitingnan ko lang or ang hinihingi ko lang yung insight niyo. Hindi importante na tama. Ang tinitingnan natin yung ma-train kayo mag-isip. Okay, so sige, 1 minute left. Yung iba na hindi pa nakakasagot, class, please give your insights sa comment section natin. Kasi i-explain naman natin yan one by one mamaya. Okay, so let's try to answer this one. Okay, so ang sagot natin class dito kayo, mag-focus tayo. Okay, so there is no violation against the rights of Miss Bawang in the filing with Staffa against her. She defrauded Miss Wa during their transaction by issuing a check which account is already closed. Miss Bawang is criminally liable under the revised penal code or the RPC for Staffa under Article 315. Nakuha? Article 315 or swindling or estafa class, any person who shall defraud another by any means mentioned therein shall be punished by, of course, yung tinatawag natin na minimum period to prison correctional class hanggang sa 40,000 pesos. Of course, not exceeding 1 million to 200,000 pesos. Okay, tandaan niyo, okay, walang violation doon against the rights of misbawang or non-payment of taxes, di ba? But of course, class, tandaan niyo, aside sa estafa na tinatawag natin, bakit kaya class, estafa ang kaniyang naging kaso? Okay, bakit kaya? Bakit kaya class, estafa ang naging kaso niya? Sige nga. Sub-question number 2. Bakit estafa class? Ano ba yung inherent na element ng estafa? Bakit sa ganitong kaso, estafa ang naging kaso niya? Of course, aside sa tinatawag natin na bouncing check law, kasi di ba she issued check which is later on, nung pinalitan niya na or pinapalitan niya na sa may bangko, walang laman pala or close na yung account na yon. May trust na sir, di ba? Okay, ano siya? Nagsa-start sa letter F. Kasi meron ng, okay, meron ng ano yung inherent na element ng estafa? Okay, very good. There is a fraud, okay, na nangyari. Okay, there is a fraud class na nangyari. That's why estafa yung kaniyang magiging kaso. So kung titingnan ninyo ang estafa, ang in-issue niya kasi na cheque, okay, ang in-issue niya na cheque is amounting to 500,000 pesos, di ba? Malaking pera yung 500,000 pesos. That's why it is a fraud, di ba? Panloloko yan sa ating kapwa. Okay, that's why there is a grave abuse of confidence or nasira yung tinatawag na trust. So yeah, that's why he is in mga manloloko. Okay, she is of course punishable yung tinatawag natin na estafa or swindling. Coach, pinagkaiba po ng estafa at qualified theft. Okay, ang estafa, of course, class, there is a fraud na nangyayari. Ang qualified theft naman, tandaan nyo, ang qualified theft, ang violator dyan is the domestic servant. Again, magiging tinatawag na nila qualified theft yan kapag yung violator is the what we call the domestic servant. Okay, domestic servant, diba? That is qualified theft. Halimbawa, PA ka niya or you are a kasambahay, then of course, ninakaw ka or ikaw yung tenant ng lupa, then of course, ang ikakaso sa iyo is qualified theft. Or, you are a police officer, isinauli sa iyo yung cellphone, thinking na yung sauli is isasauli mo sa may-ari talaga, so that is magiging qualified theft. Okay? So yan yung, of course, nagtiwala rin yung tao sa iyo na isauli mo, pero hindi mo pala isinauli. Okay? So yan yung tinatawag natin na qualified theft. Okay? So yan. Okay. So next, let's move on sa next question tayo. Okay? So I hope it's clear, class, ha? Estafa kasi nga, of course, there is a fraud na nangyari. Okay, next question. Pakibasa nga, JB. JB. Ay, hindi po. Sige.
Illustration.
Sige, illustration 2. Sige.
Ramon shot. Ay, coach na ano po, nahirapan po magsalita. Iba na lang po. Coach.
Ay, mahirap ka magsalita. Ay, nahirapan ka magsalita. Si ano na lang. Sino po ba ang available dito? Si Karina. Si Karina ba available?
Yes, sir.
Sige. Go ahead. Thank you.
Ramon shot Bong and hit in his stomach. After the shooting, Ramon fled away thinking that Bong died. Bong was rushed to the hospital for treatment. Since Bong positively identified him as the suspect, a case of frustrated murder was filed against him. Eventually, Ramon was apprehended and put to jail. While the case is pending for trial, the victim died. The family of the victim filed a motion to change the nature of the case from frustrated murder to murder. The family of Ramon contested the filing of the new charge on the ground of double jeopardy. Is the family of Ramon next po, sir?
Yes. Hindi. Hanggang doon lang. Sige. Ako na lang magtapos ng question kasi naputol to eh. Okay, so ulitin natin. So Ramon shot, sorry, ito. Hindi ko makita. Okay. Ramon shot Bong and hid in the stomach. After the shooting, Ramon fled away, thinking that Bong died. Bong was rushed to the hospital for treatment. Since Bong positively identified him as the suspect, a case of frustrated murder was filed against him kasi nabuhay. A case of frustrated murder was filed against him. Eventually, Ramon was apprehended and put to jail. Okay? While the case is pending for trial, the victim died. The family of the victim filed a motion to change the nature of the case from frustrated murder to murder. Kasi nga di ba namatay siya. The family of Ramon contested the filing of a new charges on the ground of double jeopardy. Is the family of Ramon correct? Yes or no? Tama ba yung sinabi ng family ni Ramon na double jeopardy yun? The family of Ramon, ayan. Okay. Is that double jeopardy class? Kasi nung una, di ba, frustrated murder lang kasi hindi pa naman siya namatay. Di ba? Then after that, namatay siya eventually. So meaning, merong nagkaroon ng tinatawag natin na intervening cause. Ibig sabihin, di ba, pag sinabi natin proximate cause, nung sinaksak kita, namatay ka na agad. Yun yung cause ng pagkamatay mo. That is proximate cause. Ang intervening cause naman, sinaksak kita, umuwi ka pa sa bahay niyo ng 3 days or 2 days, then after that, doon ka pa namatay. Hindi sa pagsaksak ko sa iyo, sa infection. Okay. Is the family of Ramon correct? Yes or no? Double jeopardy ba yun? Kasi di ba babaguhin from frustrated to murder, of course. Yes or no, class? Please justify your answer on the comment section. Okay, justify class ng sagot ninyo sa comment section. Dapat mag-justify kayo, meron din kayong bakit ganito, bakit hindi. So, I appreciate kapag maganon. Isa pa lang ang sumagot. Okay, no. Lahat sumagot, class. Lahat mag-participate. Para maganda yung aning discussion. No, sir. Kasi nabuhay na siya at siya mismo ang nagkaso. Hmm? Parang naguguluhan kayo sa tanong class ah. Basahin niyo muna. Basahin niyo ulit. Ayan. Di ba una, frustrated murder kasi buhay pa siya. Then later on, during while the case is pending, namatay siya. Okay? Tapos ngayon, of course, ang family ng biktima class nag-file ng motion to change the nature of the case from frustrated murder to murder. Tapos hindi naman gusto or hindi naman payag yung family ni Ramon or yung family na accused kasi nga that is against daw sa right ni Ramon na yung tinatawag natin na that is against the double jeopardy. Is that double jeopardy? Tama ba si ang family ni Ramon or hindi? No, sir. Kasi yung victim filed a motion to change the nature of the case. Then, wait lang. Wait lang, hindi ko makitinaya ko. The nature of the case and the case is pending for the case is pending. Kasi ang double jeopardy sir is kung convicted ng isang case, then mag-file ulit ng case pero similar or same doon ng mga tao ng double jeopardy. Okay? Now, it indicates in double jeopardy that may held if the person is convicted or acquitted. Besides, ang i-change the case kung these stages lang. No, sir, kasi di pa acquitted or convicted si Ramon. Okay, maganda yung mga ano niyo, mga insights. Okay. Excellent. No, because double jeopardy is a procedural defense. Sorry. That prevents an accused person from being tried again on the same charges following an acquittal or conviction. In this case, the victim filed only the motion to change the nature of the offense. Maganda yung mga justification niyo. Okay, so let's try to answer. Okay, so dito. So the family of Ramon is incorrect. Again, the family of Ramon is incorrect. The filing of a new case increasing the nature of the first case from frustrated murder class to murder does not constitute double jeopardy because of supervening event or yung tinatawag natin na intervening cause. So in the case of Carmelo class versus people of the Philippines, the Supreme Court held that after the first prosecution a new fact supervene, which the defendant is responsible, which changes the character of the offense, and together with the fact existing at the time constitutes a new and distinct offense. The accused cannot be said to be in second jeopardy if indicated for the offense. Kung titingnan nyo, nasa trial pa rin yun. Okay? Nasa trial pa rin yun. So, ibig sabihin, it can change anytime. Yung nature from frustrated kasi namatay siya during trial or undergoing, of course, that will be a murder na lang. Or yung tinatawag natin na consummated. That is in the case of Carmelo versus people of the Philippines. Okay? Kasi nga, there is a supervening event or intervening cause na nangyari. So meaning the family of Ramon is incorrect. Kasi the filing of a new case that increased the nature from the first case, from frustrated murder to murder does not constitute a double jeopardy. Unless na lang kapag yung si Ramon is acquitted or convicted of that crime. Hindi na natin siya pwedeng sampahan ng similar or related na kaso. Nakuha ninyo? Naintindihan?
Malinaw na, sir.
Okay, very good.
Yes,
So,
sir.
ayan. Thank you. Okay, next. Okay, so dapat ganun kayo mag-isip class at maganda yung mga explanation ninyo. Okay? So, meron kayong idea but then again, hindi lang siya napapolish. So, kailangan na natin ng konting fine-tuning, di ba? Fine-tuning. Okay. Meron tayong supervening event, so a doctrine in criminal procedure which holds that where new facts or such deformity for which the defendant is responsible has supervened and this new fact changes the character or nature of the crime first imputed to him so that together with the facts previously existing, it constitutes a new distinct offense, no double jeopardy exists kasi there is a supervening event. Okay? Ibig sabihin, hindi ka siya namatay doon sa nung sinaksak mo siya. Then, ang cause naman ng pagkamatay niya, yung infection ng pagkasaksak mo. Okay? Ibig sabihin, there is an intervening, there is a broken chain. Okay? Broken chain. But still, you are still criminally liable and does not constitute double jeopardy. Okay? Kasi ang i-change lang naman ang nature. Di ba? Ang nature or yung tinatawag natin na ano mo, okay? Yung magiging new offense, okay? New distinct offense. So that's why it does not violate your constitutional right to double jeopardy. Okay? So yun. Then, of course, the requisites or the graver offense developed due to supervening facts arising from the same acts or omission. Ibig sabihin, from frustrated murder, namatay siya, naging murder. So, okay lang yan. Okay? Kasi it is arising from the same or parehas or similar acts or omission. The facts constituting the graver offense arose, ibig sabihin, nanggaling or doon nanggaling or derived or were discovered only after the filing of the former complaint or information. Hindi naman natin ina-expect, di ba? Or hindi naman nila ina-expect na mamatay talaga siya. So that's why it is justifiable. Then a plea of guilty to a lesser offense was made without the consent of the prosecutor or the offended party. So yun, ang requisites ng supervening event natin or supervening cause. Then, of course, we have the rights to ex facto law or bill of attainder. Actually, naulit na natin to but still, I would like to give emphasis para, di ba, repetition is the mother of a learning. Palagi natin sinasabi. Of course, kay Dr. Peckley ko yan natutunan class. Yung paulit-ulit. Kaya that's why, kung nagdi-discuss ako, palagi ko inuulit-ulit yan. Kasi that is tested and proven naman, di ba? So under Section 22, no ex post facto law or bill of attainder shall be enacted in the Philippines. Di ba? Pag sinabi natin ex post facto law, it is the one or it is the law that makes a criminal an act done before the passage of law. Innocence when done and punishes a act. Halimbawa, hindi mo pwedeng on the case, di ba, yung kay Katrina Halide and hindi mo pwedeng bigyan ng punishment yan. Okay? Kasi for the time na na-commit niya yan is wala pang law na nagpo-prohibit or nagko-consider na illegal yung action ng tao na yan. So that is against the ex post facto law, di ba? Under Section 22 of the Constitution, no ex post facto law or bill of attainder shall be enacted in the Philippines. So bawal yan. Then bawal ulit ang bill of attainder kasi ang bill of attainder class as a review, it is a legislative act which inflicts punishment without trial and hearing. But then again, it violates yung tinatawag natin na due process of law. In the due process of law, di ba pag sinabi natin due process of law, It is a type of law that hears before it condemns, proceeds upon inquiry and renders judgment only after trial. Ibig sabihin, magkakaroon muna ng proper trial and hearing before you will pronounce that a person is guilty beyond a reasonable doubt of a particular crime. Again, wala tayong ex post facto law or bill of attainder sa Pilipinas. Okay, nakuha niyo? Wala tayong ex post facto law or bill of attainder sa Pilipinas. Okay, sir, pwede po ba hingin ng scenario ng bill of attainder? Okay, so yes, bibigyan natin tayo. Ang bill of attainder class, halimbawa, okay, so it is a legislative act kasi, ibig sabihin, ang legislative branch of the government natin, di ba, sa Senate and the House of Representatives, yung mga congressman and congresswoman natin, di ba? So, sinasabi sa Bill of Attainder, kasi ang Bill of Attainder class, sa ibang bansa yan. Okay, ang Bill of Attainder, wala yan dito sa Pilipinas. Okay, hindi tayo basta-basta magkaroon ng Bill of Attainder dito sa ibang bansa. Sa kanila doon, ang Senate or ang House of Representatives, yung congressman and congresswoman nila, can give punishment right away without trial and hearing. Sasabihin nila, okay, guilty ka sa ganitong krimen. Okay? Pero sa Pilipinas, wala tayong ganyan. Sa atin, magkakaroon tayo ng preliminary investigation para malaman kung may probable cause. I-determine pa yan personally ng judge kung meron before siya labas ng warrant of arrest and so on. So again, ang Bill of Attainder, wala tayong ganon. Ibig sabihin, hindi pwedeng sabihin ng judge or any administrative bodies, okay, na guilty ka class kasi nga gusto lang nila, wala silang basis. Dapat magkakaroon muna ng proper trial and hearing. Okay, so ayan, welcome. Okay, so kapag may mga tanong pa kayo, i-comment nyo lang dito sa ating comment section. Okay, next tayo. Okay, so we have the kinds of ex post facto. Bakit ayaw? Okay, wait lang class. Ano ko lang. Again, so we have the kinds of ex post facto. So the number one, every law that makes criminal an action done before the passage of law, which was innocent when done and punishes such action. Of course, na-explain ko na yan. Every law that aggravates a crime or makes it greater than it was committed. Anong example yan? Hindi mo pwedeng taasan, halimbawa, ang kaso ngayon is, ang penalty mo sa crime na ganito, ng murder is reclusion perpetua. Hindi mo pwedeng itaas yan, class, sa death. Kasi nga, that is not allowed in the Philippines. Wala tayong ex post facto law. Ibig sabihin, it aggravates a crime or makes it greater than it was committed. Ibig sabihin, tataasan mo ngayon ng penalty, that is bawal. Kasi nga, halimbawa, in 2022, ang crime ng murder is punishable by reclusion perpetua. Then, on the 2023, nagkaroon ng bagong batas na nagsasabi that the crime of murder is punishable now of death. That is not allowed, class. Kasi nga, that is in violation of ex post facto law. Wala tayong ex post facto. Kung ano yung original punishment na ibinigay sa iyo ng korte, yun yung susundin. Kasi nga, wala tayong ex post facto law. Okay? Then every law that changes punishment and inflicts a greater punishment than the law annexed to the crime when committed. Nakuha ninyo, class? Naintindihan nyo ba ang ex post facto law? Ibig sabihin, hindi mo pwedeng sabihin na illegal yung action na yan kung walang batas na nagpo-prohibit na illegal yan. Okay, kasi nga, di ba, our criminal law is prospective in nature. Hindi bumabalik, we are futuristic. Hindi mo rin pwedeng taasan yung penalty ng crime kung saan meron na siyang penalty na binigay originally given by the court. Kasi nga, that is in violation against yung tinatawag na ex post facto law kasi nga we don't have ex post facto law in the Philippines. Okay? I hope nakuha nyo na ang tinatawag na ex post facto law and bill of attainder. Okay? Then, of course, ayan, every law that alters the legal rules of evidence and receive less or different testimony, commission of an order to convict the offender. So, wag na natin masyadong focus to. Basta importante yun yung tandaan ninyo. So dito na tayo sa characteristics of ex post facto law. Of course, it refers to the criminal matters. It is retroactive in application. Kaya class, sa ibang bansa, meron silang tinatawag na ex post facto law. Sa atin, wala tayong retroactive effect. Ibig sabihin, hindi tayo bumabalik sa nakaraan. We are futuristic. So, hindi natin pwedeng i-apply ito. It works to the prejudice of the accused. Kasi di ba, again, pwede natin i-apply ang bagong batas unless it is favorable to the accused. Pero kapag may ex post facto class, it prejudice yung rights. Ibig sabihin, napapahawak dito ang rights ng tinatawag natin na mga accused. Kasi again, our criminal law is prospective in nature and always favorable to the accused. Diba? In dubio pro reo, in doubt for the accused. Ibig sabihin, ang mananalo ngayon ang accused. So that is the characteristics of what we call ex post facto law. Nakuha? Okay, next. Of course, the Office of the Commission on Human Rights and its constitutional mandates or yung tinatawag natin na CHR, di ba? So under Article 8 of Social Justice and Human Rights, this is hereby created an independent office called the Commission of Human Rights or the CHR. So ang CHR natin class, of course, alam niyo naman ang CHR. So number two rather, the commission shall be composed. Okay, so number two, the commission shall be composed of the chairman and of course 4 members who must be a natural Filipino-born citizens of the Philippines and a majority of whom shall be members of the bar. So particularly mga abogado talaga class ang member of the human rights. The term of office and other qualification and disabilities of the members of the commission shall be provided by the law. Until this commission is constituted, the existing Presidential Committee on Human Rights shall continue to exercise its present functions and power. So the approved annual appropriations of the commission shall be automatically and regularly released. Again, ang Commission on Human Rights, of course, sila class yung major or yung sila yung tinatawag natin na commission na nangangalaga when it comes sa ating human rights, particularly class sa mga accused, di ba? Kaya that's why kung napapansin niyo sa Pilipinas, pinapangalagaan talaga ng human rights ang tinatawag natin na accused. Okay? So yun ang trabaho ng tinatawag natin na CHR or the Commission on Human Rights. Okay, so the Commission on Human Rights, class, meron silang powers and functions. Una dyan, to investigate in its own power, okay, yung mga complaint or any party or all forms of rights violations involving civil and political rights. Second naman, to adopt its operational guidelines and rules of procedure and cite for contempt for violation thereof in accordance with the rules of court. Of course, pwede silang mag-contempt. Or provide appropriate legal measures of protection human rights and all persons living in the Philippines. Of course, ang human rights ang bahala dyan. Kasi di ba, they investigate, they adopt, and they provide legal means or legal measures for the protection class ng human rights ng Pilipinas para to make sure na meron pa rin tayong human rights. Kasi nga, kapag wala tayong human rights existing in our country, manghihimasok na ngayon ang tinatawag natin na International Criminal Court or the ICC na matatagpuan natin sa The Hague, the Netherlands. So that's why very important na nandyan or meron tayong Commission on Human Rights or the CHR. Okay, so number 4, exercise visitorial powers over jails, prisons, or detention cells. Titingnan din class ng CHR kung yung treatment of the prisoners, nasusunod ba yun? Yung Universal Declaration on the Treatment of Prisoners, nasusunod ba yun or hindi? Kasi nga, i-visit nila yung prisons and of course yung mga jails natin under the BJMP. Number 5 naman, establish a continuing program of research, education, and information to enhance respect for the primary or privacy of human rights. Number 6, recommend to the Congress effective measures to promote human rights and to provide for compensation to victims of violation of human rights or their families. Kasi di ba, there are victims na, of course, di ba, forgotten person ng victim. So, of course, trabaho rin yan ng ng human rights to provide or to give recommendation or measures to the Congress on how to improve yung tinatawag natin na human rights in our country. Number 7, monitor the Philippine government's compliance with the international treaty obligations on human rights. Okay, so yan ang trabaho. Of course, to grant immunity from prosecution to any person whose testimony or whose possession of documents or other evidence is convenient. Of course, pag-grant immunity, ibig sabihin, you are not allowed to arrest that person or to file case on that person. Number 9, request the assistance of any department, bureau, office, or agency in the performance of its function. Number 10, appointment of its officers and employees in accordance with law, and perform all such other duties and functions as may be provided by law. So that is self-explanatory naman, guys. Don't worry. After this discussion, isi-send ko naman yung PowerPoint na to para mabalikan ninyo. Then, of course, na Section 19 class, the Congress may provide for other cases of violation of human rights that shall fall within the authority of the Commission, taking into account its recommendation. Di ba? Trabaho ng CHR to recommend or to provide recommendation to the Congress on how to improve our human rights na meron tayo sa ating bansa as of now. Okay? Then, of course, meron tayong tinatawag na rights under the Universal Declaration of Human Rights or the UDHR. Okay? Universal Declaration of Human Rights. Okay, next. Okay, so we have the free and equal. Ibig sabihin, all human beings are born free and equal and shall be treated the same way, or they should be treated alike. All human beings are born free and equal in dignity and rights. They are endowed with a reason and conscience and should act towards one another in a spirit of brotherhood. Free and equal. Ibig sabihin, may liberty, and of course, hindi tayo tumitingin sa race, sa religion, sa color, kung ano may yung status mo sa buhay. Ang ating human rights is universal in application. We are all equal. And of course, we are free from freedom from discrimination. So everyone can claim their rights regardless of sex, race, language, religion, social standing, and etc. So no discrimination, no bullying na mangyayari. So that is under the Universal Declaration of Human Rights. Then, of course, the right to life. So ibig sabihin, everyone has the right to life and live in freedom and safety. We have the right to life. We have the right to choose kung sino yung mamahalin natin. We have the right to choose who will marry, kung sino yung papakasalan natin. So that is our right. So of course, everyone has the right to life, liberty, and security of person. Ibig sabihin, kailangan na natin ng security. That's why, di ba, kapag nanganganib ang buhay natin or our life is in danger, kailangan natin i-report yan sa authorities class para mabigyan tayo ng extra protection. Okay? Kapag ang ating life is threatened or violated. The right to life. Then, of course, freedom from slavery. Ibig sabihin, no one has the right to treat you as a slave, nor should you enslave anyone. Diba? No one shall be held enslaving or servitude. Ibig sabihin, itago ka sa na walang contact yung parents mo, walang contact yung ibang tao sa iyo, so that is not allowed under the law. Then, of course, freedom from torture. Diba? Sinabi natin kanina, no one has the right to torture you. No one shall be subjected to torture or to cruel, inhumane, or degrading treatment or punishment. Sorry. The right to recognition before the law, ibig sabihin, you should be legally protected in some way or the same way everywhere like anyone else. Ibig sabihin, yung pag-enforce ng batas natin, class, wala dapat pinipili. So everyone has the right to recognition everywhere as a person before the law. Hindi lang yung mayayaman, of course, hindi rin yung mahihirap, di ba? So Article 7, the right to equality before the law. Ibig sabihin, the law is the same for everyone. Kaya di ba, it is just, okay? So what is law? It is the rule of conduct, just and obligatory. Ibig sabihin, there is a fairness among all and should be applied in a manner to all, equality before the law. Article 8 naman, access to justice. Ibig sabihin, you have the right to obtain legal help, access to the justice system when your rights are not respected. That is access to justice. Then, of course, freedom from arbitrary detention. Ibig sabihin, hindi ka pwedeng arestuhin class arbitrarily, ibig sabihin without the legal grounds or without legal course, and no one shall be subjected to arbitrary arrest or detention or exile. Okay? So hindi ka pwedeng ikulong ng public officer or employee without due cause or without legal grounds kasi gusto niya lang. So that is against the, of course, yung tinatawag natin na arbitrary detention. Then, of course, Article 10, we have the right to fair trial. Ibig sabihin, trial should be a public and tried in a fair manner, impartial and independent tribunal. Again, pag sinabi nating fair trial, of course, anyone can access or anyone can witness the trial and hearing. But then, it's up to the victim kung i-request niya sa korte kapag yung subject or yung kaso is confidential in nature. So yun ang the right to fair trial. Then, of course, we have Article 11, yung presumption of innocence. Okay, in Article 11 class, meron tayong tinatawag na presumptions of innocence. Ibig sabihin, you are considered innocent until it can be proved you are guilty according to law, di ba? So that is the primary right of the accused. Okay, so di ba the presumption of innocence. If the accused of a crime, you have the right to defense, of course, you have the right to counsel, preferably with your own choice. So that is presumption of innocence. Then, of course, we have the right of privacy. Ibig sabihin, you have the right to protection if someone tried to harm you, or your good name, enter your home without permission, or interfere with your correspondence. You have all the right of privacy. That's why kapag na-violate yung privacy mo class, pwede kang mag-issue or pwede mag-request sa korte na mag-release ng tinatawag natin na writ of habeas data. That is the writ of privacy or the right of privacy. Then Article 13, freedom from movement. Ibig sabihin, you have the right to live or move within your own country and you should be able to return in your country. Kasi of course, meron tayong tinatawag na, di ba, persona non grata. Pag sinabi natin persona non grata, ibig sabihin you are unwelcome. Ibig sabihin, hindi ka welcome sa lugar na yan. But still, you can go there as well. Okay, pwede ka pa rin pumunta sa lugar na yan, but then again, baka kuyugin ka ng ibang tao, di ba? So that is persona non grata. Then everyone has the freedom of movement and residence within the borders of the states. Then everyone has the right to live in any country, including his own, and to return his own country. Freedom from movement. Pwede kang lumabas, pwede kang bumalik anytime you want. Then the right to asylum. Ang right to asylum, if you are prosecuted or you are persecuted at home, you have the right to seek and to enjoy in any other country's asylum from persecution. Okay? So, asylum, ibig sabihin, magkakaroon ka ng protection class from that government or from our government. So, yan yung asylum. The right to nationality, ibig sabihin, you have the right to belong or to belong to a country and have nationality, Filipino, Chinese, Korean, and so on. Right to nationality. Then the right to marriage and to found a family. Ibig sabihin, men and women have the right to marry each other when they are legally able, of course, na sa tamang edad, without limits to race, nationality, or religion. So families should be protected by the government and the justice system as well. Then, of course, Article 17, the right of property. Ibig sabihin, may karapatan kang bumili ng properties and karapatan mo rin na i-dispose yung property mo or ibente yan. So that is the right to property. Then, of course, Article 18, freedom of religion or belief. Ibig sabihin, pwede kang mamili class ng religion ninyo. Okay? So, of course, kasi nga, di ba, nasa, ano mo yan, nasa tamang edad ka na or nasa namang disposisyon ng buhay ka. Religion, kasi di ba, hindi naman magsisave ang religion sa iyo, ang faith naman ang magsisave sa iyo. Then freedom of expression, ibig sabihin, everyone has the right to think and say what they like and no one else should forbid it. Ibig sabihin, kung ano yung nararamdaman nila, kailangan nila i-express yun. Okay? In actions, in words, that is freedom of expression. Then of course, bawal yan i-prohibit or bawal mo pagbawalan yun, yung freedom na yan. Then of course, freedom of assembly. Ibig sabihin, you have the right to organize and participate in peaceful meetings. Assembly, ibig sabihin, pwede kayo mag-assemble. Pwede ka mag-attend ng seminars, trainings, and so on. So yan yung freedom of assembly. Then, of course, we have Article 21, the right to partake in public affairs. So, ibig sabihin, everyone has the right to take part in their country's political affairs and equal access to public service. Government should be voted regularly. Ibig sabihin, kailangan mo mag-participate class in any government services. Halimbawa, yung sa darating na election, dapat kang lumabas at bumoto kasi that is your political rights. Of course, kung kung tumakbo ka, the right to vote and be voted for in the public office. Okay, so yan yung the right to partake in any public affairs. Okay, so yan. Okay, so yan yung mga right to partake in any public affairs. Okay, so the right, next. The right to social security, ibig sabihin, society should help individuals to fully develop and make the most of all advantages offered in their country. Ibig sabihin, yung mga opportunities, dapat hindi mo lang yan kinikimkim or dapat isi-share mo yan sa iba. Okay, so yan. Yung the right to social security. Then, of course, the right to work. Ibig sabihin, everyone has the right to work in just and favorable condition and be free to choose your work with a salary that allows you to live and support your family. So, may freedom ka to choose kung anong environment. Okay, di ba? Kahit malaki yung sahod, kung ayaw mo na. So, hindi ka pwedeng i-hold. So, everyone should receive equal pay for equal work. Ibig sabihin, kung ano yung effort mo, kung ano yung credentials mo, of course, dapat yun rin yung magiging corresponding payment. Okay? So yan yung tinatawag natin na the right to work. Okay? So everyone should receive equal pay for equal work. Okay? So yan yung Article 23. Okay, next. We have the Article 24, the right to leisure and rest. Ibig sabihin, pwede kang maglagalag, pwede kang pumunta sa ibang lugar, and of course, pwede kang magpahinga, di ba? Of course, and periodic holidays with pay. Okay? The right to leisure and rest. Okay? Nakuha niyo? Then, of course, the Article 25, the right to an adequate standard of living. Ibig sabihin, you have the right to have what you need. Okay? Kailangan kang sumikap. And your family do not go to hungry, ibig sabihin, hindi magutom and homeless or fall ill. Okay, the right to adequate standard of living. And the right to education as well. Ibig sabihin, karapatan mo yan to go to school, continue your studies as far as you wish, and learn regardless of race, religion, or country of origin. Diba? The right to take part in the cultural, artistic, scientific life. Of course, to participate in cultural life of community. Then, of course, your interest, kailangan mo yan, of course, free ka to join in any cultural, artistic, and scientific life. Then the right to a free and fair world, ibig sabihin, everyone is entitled to social international border or order in which freedom yung recognized. So di ba kapag halimbawa, yung batas or yung kapangyarihan ng mga batas sa bansa ninyo is not fully or recognized. But of course, meron international guidelines to protect you as well kapag hindi gumagana yung dito sa national. The rights are inalienable. Ibig sabihin, no one or no institution or individual should act in any way to destroy the rights enshrined in the Universal Declaration of Human Rights. Dapat, ano yan, every state class na member ng Universal Declaration of Human Rights shall abide the rules na sinabi ng UDHR. Okay? So, of course, class, we have the special laws providing penalties to violating the rights of a person. We have Republic Act number 103-683. Ayan yung Victims of Human Rights. Anti-Torture, 9745. Anti-Child Pornography. Cybercrime Law, yung Act number 10, Republic Act 10175. And of course, yung Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity. Okay? So yun, class, ang mga crimes. Of course, we have yung Terrorism Act. Of course, napalitan na ngayon class ng 11479. Okay, yung terrorism. Human security, of course, the anti-hazing law, anti-sexual harassment, violence against women, the 9208, yung anti-trafficking, Anti-wiretapping, rights detained, of course, yung 7438. Then, of course, we have the special violence 9344, the RA 10002, and so on, speedy trial, na explain na natin to class, and of course, and others. So, yan. Yun yung ating, okay, natapos na pala natin. Of course, class, ibibigay ko tong presentation natin mamaya. Okay, so ayan. So, let's end our discussion class on our human rights education. So, marami pa kayong nakuha ngayong gabi. Marami kayong napag-aralan. Okay, so ayan. So, on the, titignan ko bukas kasi kung ano, kung mag-lecture tayo. Ano nga bukas? Friday? Ay, Tuesday pa lang at Wednesday pa lang pala bukas. Wednesday, baka ano tayo, mag-lecture ulit Thursday or Friday kasi bukas flight ko pa uwi sa Jensen. So, rest day. After ko rest class na naman tayo sa criminal law book 2. Sorry. Okay, sa book 2 na tayo. Okay, so thank you for joining our boss. Sorry.